Did you know that the standard for accommodating sincerely held religious beliefs in the workplace has changed? Recently, the U.S. Supreme Court held that an employer must show undue hardship that substantially burdens the employer's business overall before denying an accommodation to an employee's religious belief or practice. This standard is similar to what is required when accommodating an employee's disability. I'm Alex Rubin, owner of Rubin Employment Law. In this video, I'm going to explain what undue hardship means now and what you must do to accommodate religious beliefs under the new, higher standard. Please keep in mind this is general information, not legal advice, and the law may change at any time. First, a brief history lesson. Previously, the standard for accommodations for religion in the workplace was that it had to impose more than a de minimis cost on the employer for the accommodation to be denied. Now, employers have to show undue hardship to deny an employee a religious accommodation. There's that phrase again, undue hardship. So, what's an undue hardship, you ask? It's something hard to bear and not just a mere burden. Specifically, it must cause substantial increased costs to the business in light of the employer's nature, size, and operating costs. Coworkers' preferences don't count, nor does reduced employee morale or disruption to the workplace and workflow. Let's take a look at the situation in the U.S. Supreme Court case that changed the standard for religious accommodations. There, a U.S. postal worker requested to be exempt from working Sunday shifts due to his observance of the Sabbath on Sundays as an evangelical Christian. The employer argued that granting the accommodation would impose a burden on the employee's coworkers and thus was an undue hardship on the company. The U.S. Supreme Court rejected this argument. The court held that to be denied, an accommodation must impose an undue hardship on how the employer conducts its business, regardless of the effect of the accommodation on coworkers. One possible accommodation in this scenario would be voluntary shift swapping among employees, perhaps with the use of incentive pay. So, before you reject a religious accommodation request, be sure you can demonstrate that the cost to the business would be excessive or unjustifiable. Let us know in the comments what you think and what your company is doing to accommodate religious beliefs or practice in your workplace. For more information, read our blog at alexrubinlaw.com/employment-blog.